Hi, I'm James Longster, and thanks for joining another Travis Smith Tech Spotlight. As always, Tech Spotlight will be bringing you short and snappy updates on tech and data issues. In this edition of Tech Spotlight, I'm going to be talking about the importance of data and why it's a current political issue. Now, this was a topic that was on my to-do list, but it's hurtled up the agenda by the decision of the EU's top court, the CJEU, in Schrems II. Now, I'm not going to dive into the detail of that case, as that would be neither short nor snappy. But if you want more information on this, then please see our detailed briefings. The key takeaways from the case, though, are firstly, that the CJEU has invalidated the transatlantic transfer mechanism known as Privacy Shield on largely state surveillance grounds. Secondly, the CJEU has upheld what are known as standard contractual clauses or model clauses, but emphasised the importance of data exporters and regulators assessing the wider position on data protection in the importing country. So why is this important? Well, the starting point is that EU companies can't transfer personal data outside the European Economic Area unless a valid transfer mechanism is in place. Privacy Shield was one, standard contractual clauses are another. Now, Privacy Shield was used by roughly 5,000 businesses in the US to receive personal data. Now, that might not seem like a lot of companies given the scale of the US, but each of those businesses are likely to have had a large number of EEA customers, hence them thinking it was worth certifying under Privacy Shield in the first place. Now, whilst we don't actually have data for this, the quantity of personal data transferred under Privacy Shield was therefore likely to be vast. This route has disappeared though, much like Privacy Shield's predecessor, Safe Harbor, did in 2015. Unlike in 2015 though, when the natural follow-up for businesses was to put standard contractual clauses in place, the CJEU has shone a spotlight on when these can and can't be used. Now, data is a hugely valuable commodity in the modern economy, and we saw its importance in Theresa May's government when it was one of the first points addressed in her version of the UK-EU political declaration. So what we're seeing at the moment is the bubbling to the surface of a digital trade war being fought through legislation and the courts. The EU is saying to the US, your standards on data protection are not high enough, and it's trying to impose its own standards on the US, with a likely outcome of an onshoring of personal data to the EU. So where does the CJEU's decision leave the UK's future trading arrangements? Well, on the one hand, at the end of the transition period, or very soon after, the UK will hope to obtain an adequacy decision from the EU so that personal data can flow freely from the EU to the UK. That was already by no means a given, but it's now abundantly clear that a marker has been put down with regards to state surveillance. So the question will be, is the UK's investigatory powers legislation acceptable? On the other hand, the US's summary of its negotiation positions for a UK-US trade deal have expressly stated that rules should be avoided which restrict cross-border data flows. And in a rather circular fashion, we then come back to that much hoped for adequacy decision for the UK, with the European Data Protection Board has already said that transfers from the UK to other locations must be taken into account in assessing the UK's adequacy. So can the UK have its cake and eat it on this point? In the short term, it's difficult to see how this is possible until a third incarnation of the EU-US transfer mechanism is ready, or if the UK can concoct some form of mechanism with the US which meets EU requirements too. Now, this is a hugely important and interesting question for lawyers in this area, but more importantly, it's of fundamental importance to the way in which companies set themselves up and do business with their customers and suppliers. We need to see answers on these points from regulators and politicians so that the business community can prepare and plan. We will, of course, be watching for any guidance on this, but in the meantime, businesses should, as a matter of priority, review what personal data they're exporting, where that personal data is going, what security measures are being put in place in respect of that personal data, and the legal basis for the transfer. Armed with this information, businesses will be able to make informed decisions and be as prepared as possible. That's all from this edition of Tech Spotlight. I hope you can join us again soon.